Hello. Good evening, Debarati madam.
Good evening, sir. Am I audible?
Yes, you're audible. So we'll be starting at 7 o'clock. So
Yes. Sure. No issues. Okay. Am I permitted to show my PPTs?
yes, we will do after your introduction.
Yes.
Yeah, we'll make you
Yes, sir.
presenter.
Yes, sir. Yes. Okay.
I hope I'm audible. Hello, am I
Yes,
audible?
madam. Yes, you are audible.
Good evening,
Yes.
everyone. Let me introduce myself. My name is Pooja Lakshmi, and today I invite each and every one of you to embark on this transformative journey of professional growth, collaboration, and innovation. Let's embrace the changes, challenges, and opportunities of the 21st century, guided by the expertise of the speaker. Today, we can shape the future of legal education, and welcome to the first ever 1 month national level faculty development program on teaching law in the 21st century, a collaborative effort between Law Teachers India and Gujarat Maritime University, Gandhinagar. This program is a testament to our shared commitment to advance legal education and prepare educators for the challenges and opportunities of the 21st century. Today with us, we have our faculty coordinator, Dr. Pooja Chakrabarti, the head of the Department of Forensic Science and Criminology, and Fatima College of Arts and Science, Madurai. Over to you, ma'am.
Very good evening, everyone. I hope I am audible.
Yes.
We all know at what an alarming rate the cyber crimes are increasing in India, and we are lucky enough to have with us none other than Professor Dr. Debarati Halder to speak about the strategies to frame and to teach about cyber laws in the legal school. Professor Dr. Debarati Halder is presently working in Parul University, Gujarat, as a full professor. She is the honorary managing director of the Center for Cyber Victim Counseling which is an online, not-for-profit organization and a think tank which is specially meant for helping and counseling the victims of the internet and digital communication crime victims. She had won 2 awards in 2019 for her work on cyber laws, gender rights, therapeutic jurisprudence, medical criminal laws, and creating awareness on cyber crimes against women. These are Web Wonder Women Award by Ministry of Women and Children Affairs, Government of India, and Twitter on 6 March 2019. And next was the Tech Next India 2019, the Best Faculty of the Year, awarded by Computer Society of India, Mumbai chapter on 28 September 2019. Dr. Debarati Halder has developed a theory called Irrational Coping Theory for Online Victimization, which is published as a book chapter titled Irrational Coping Theory and Foster Criminology, a framework to protect victims of cyber crime. She has written numerous books on cyber law as well as cyber victimology. We are very glad to have a personality like that of hers to teach us about cyber laws today. Her work goes on closely with intermediaries like Facebook, etc., government stakeholders like NCRB, even the National Commission for Women, state commissions for women, and commissions for protection of child rights, etc., to help them shape the new policy guidelines towards protection of women and children from the online offenses. She has also been invited by government stakeholders like Bihar, Kerala, West Bengal, Tamil Nadu, Gujarat, etc., for commissions for protection of child rights, Maharashtra Commission for protection of women rights, etc., for imparting training to stakeholders committed for the protection of child rights. She has assisted UNICEF India in creating child online safety related materials, including child online protection in India. Dr. Debarati Haldar, she is an expert resource person on cyber law, cyber security, cyber crimes against women and law, online child protection, criminal laws, victimology, and penology, etc., for many national and international policy making bodies. She is also invited as expert resource person by courts and institutes, including Manipur High Court, Northeastern Police Academy, Meghalaya, KIT Law School, Bhubaneswar, etc. We can go ahead another 1 hour to introduce our speaker, but without any more delay, I would like to request ma'am to take over the stage. It's all yours, ma'am. On behalf of everybody, I extend a warm welcome to you.
Thank you. May I start sharing my PPT?
I'm making the presenter, so we'll be able to do. Okay, madam, you can try me.
Okay. A very good evening to all of you. I hope my PPT is visible to all of you.
Yes, yes, ma'am.
Okay. Thank you, organizers, including GMU and also Pro Bono, for inviting me and also for giving me opportunity to uh, uh, have a session with all the law teachers. And as such, my topic that is given to me is strategies for teaching cyber laws in Indian law schools. Let me start with the understanding, or let me start with the concept that, what is the reason behind introducing cyber law in the Indian legal, education system. Uh, until 2019, or even 2020 also, I did not get to see many law schools, including the private law schools also, have introduced cyber law as a core credit course. There are institutes who have basically introduced cyber law as an optional subject. There are law schools which have also okay. There are also law schools which have introduced cyber law as credit course, but with less credit. That means that not full attention has been given to cyber law. Let me tell you that this is the reason that we do not get proper cyber lawyers. In our generation, basically, I'm not talking about the students, I'm not talking about the young assistant professors who have just now joined, or the associate professors, or the assistant professors who have already crossed 8 or 9 years of experience. But I'm talking about people like us who are in the industry, legal industry, for a long time. For us, we are self-learned persons, we are self-learned practitioners. Basically, we know cyber law as such, Information Technology Act was introduced in the Indian legal scenario only in 2000. That means that at the time when we were getting to see many other laws coming up, but cyber law, or rather I would say Information Technology Act, was not given that kind of attention as the attention was given to some other laws. Then we do get to see in 2012, 2013, etc., because of Nirbhaya incidents, criminal law, especially Indian Penal Code, that had gone a complete revamp. We do know that Section 354 series was introduced, whereby we have also seen that women were given special status as victims. And unfortunately, men were given special status as accused persons or the perpetrators. I have contacted the lawmakers. I have contacted many other parliamentarians to make this very clear that women are not necessarily always the victims and men are not necessarily always the perpetrators. I will tell you that this particular session will all make you understand that why cyber law is essential for Indian legal system. And this is one of the examples whereby there is a misunderstanding, I would say, about how to treat people on the cyberspace and also off the cyberspace, and how to treat cyberspace, from legal understanding. Very recently, we did get to see that Chat GPT is being used for making laws. Now, when Chat GPT itself does not have any proper legal understanding or any proper legal, profile, how can a country can basically call for Chat GPT for making, some kinds of statutes? Some of you might be asking the question that, how come Chat GPT can make the statute? To make it very clear, the lawmakers basically have taken the help of Chat GPT, not only Chat GPT, but many other applications, many other websites, to make some statutes, including Wikipedia, which may not have proper standing in the education or higher education system. Forget about legal education system. Further, I would also like to mention it that today we are getting to see many public interest litigations are basically being junked. Especially these public interest litigations are coming from the perspective of information technology, communication technology, digital technology related rights. You are getting to see that the Supreme Court or the High Court, etc., they are categorically telling that there is no reason for such kinds of public interest litigations. They're also directing the students, they're also directing the young lawyers to go and have a proper understanding of information technology law, criminal law, etc., before coming up to file certain kinds of public interest litigation and also private interest litigations. Further, we are also getting to see that there are tech companies who are making their own policies, and obviously these tech companies are all based in US, but we are also making simultaneously parallel laws to counter them, parallel policies to counter them. My question to all the teachers is that why we cannot produce proper cyber lawyers, or the lawyers who will be practicing in the cyberspace, who can defend their clients in a proper fashion. Many years back, I mean, standing in 2023, I can actually say that 2013 cases or 2012 cases, these are basically many years back, we started getting to see there are lawyers from Maharashtra specifically, because this lawyer is a very close friend of mine, who stood up against the banks, because the banks denied their responsibility about, say, for example, credit card fraud, or for example, ATM fraud, etc., banking frauds. Why? Because the banks told that it is the responsibility of the customers to look after their pin, look after their ATM related information, net banking related information. And this lawyer, he started winning the cases against the banks. And these banks, I'm not naming the banks, these banks now have been considered as the safest banks in India. Now tell me that banks also have got their lawyer, the banks have got their legal advisors also, and these legal advisors are from the colleges that we teach in. Now, why these legal advisors cannot defend their clients, that is the banks? Why these legal advisors, or why the young lawyers, they cannot make a proper point whereby the foreign companies, especially the tech companies, they are escaping from their liabilities? Say, for example, I have worked with Facebook, I still work with Facebook. In fact, yesterday there was a meeting for all these stakeholders where I was a part, but unfortunately I could not be there due to my other commitments. But I do know these tech companies come for such kinds of meetings, etc., to basically know what's happening in the Indian legal system, what's happening in the European legal system, etc. And finally, they gather all the information. They use their own, legal system to create a foolproof system whereby they can escape the liabilities. Why it is happening? We have seen IT Act rules 2021 also coming up. These rules, not only 2021 rules, but there are rules in 2022, 2023 rules are also there. But we do get to see that irrespective of all the rules, laws, etc., whereby we do have punishment, strategies for punishment, etc., these companies basically are escaping all the liabilities. They're representatives for South Asia, they're representatives for India, etc. They are resigning from the companies, but the companies are like nonchalant. Why this is happening? In my understanding, because we are not able to understand what exactly is cyber law, what exactly is Information Technology Act, and in which direction the entire global understanding of information technology law is going. For example, when I look into the syllabus of many institutions, including some national law universities also, I'm really surprised and shocked to see that there are mixing of two spices. One is regular cyber law, the other is intellectual property right related laws. Even though they are connected, but they are not the actual things. They should not be served in same platter. They have got different tastes, they have got different flavor, and they have got different, I would rather say, impacts. Therefore, these two what you call subjects must be kept in different categories, and they should be served in different manner. Anyway, today I'm I want to discuss about all these strategies, challenges, etc., and I hope that all of you will be enjoying, at the same time learning certain things about how to teach cyber law in the institutions. I will make it okay, fine. So now comes to the question of significance of cyber law in contemporary legal practice. As I was telling, even though we have named it as cyber law, there's nothing like cyber law. There are different understandings about one particular stream of law that is addressing cyberspace, that is regulating cyberspace. And these laws basically are scattered. For example, digital communication, information technology, information related laws, free flow of information. Then comes the question of privacy, consent related laws, data processing related laws, data protection related laws, cyber security related laws, etc., etc. If I want to talk about significance of cyber law in the contemporary legal practice, just take up any of these four subjects that you are getting to see. For example, I will be taking up international law. Presently, you ask any student of the graduation, undergraduate stream, whether it is 3 years undergraduation stream, or whether it is 5 years integrated undergraduation stream. You ask him anything related to international law. Say, for example, you want to ask him anything related to law of war. So the first question that student will be answering is, law of war is something that Wikipedia gives. What does it mean? Wikipedia basically is a platform that has collected certain information from different sectors, and it has served a kind of knowledge or information to the students. Therefore it is known as international law. What we are getting to see, the basic understanding of international law is coming from the cyberspace. Nobody is actually looking into the book. But at the same time, if you ask him about any sort of conflict, any sort of legal challenges, etc., on international law, that student might not be able to tell, because there is some kind of legal challenges, legal battles, etc., are being fought, which is not shown to the public, some of which are published to the for the public. Now this international law is heavily dependent on the human behavior. We all know about international law jurisprudence, human behavior, human society, national state government behaviors, etc. What does cyber law has to do with this? Imagine or think about Kosovo conflict. If anyone knows about it, fine. If you don't know about it, then let me explain this. These things happened way back in 2012, 13, etc. And the same Russia and other states problem basically came up. NATO conflict. That is also related to information technology related, digital communication related, conflicts. Not only that, you all probably would be knowing about Black Tigers attack. This was one of the first kind of uh, cyber terrorism attack that actually happened in Sri Lanka. What happened there? Basically, we do get to see, if you read about Black Tigers attack in Sri Lanka, um, basically the LTT people, they started jamming the emails of the embassies, and these embassies could not get connected with, and this is basically 1990s case, I mean fag end of 1990s. So these embassies could not connect with their homeland. Not only that, we are also getting to see that international law instruments, etc., these are all available on the cyber platform. But do you know that how these kinds of instruments are made? Often you will be getting to see that the international platforms or international organizations, they're basically asking for opinion, and how these opinions are collected. This is nothing but a data collection, or rather I would say that it's a kind of survey, I'm sorry, collection of the responses from different stakeholders, and it is data processing of that particular data which has been collected from different stakeholders, and that can be you and me, that can be any government officials, that can be any government office, etc. International law is also connected with, say for example, digital communication technology related laws. Therefore we do get to see about EU GDPR. Everybody is talking about that now. We are also getting to see some kinds of SARC countries laws, that is also connected with international law and cyber law. We cannot deny the fact that almost all of us are doing research on cryptocurrency, and cryptocurrency related issues are also connected with international law. Further, we are also, and when we are discussing about cryptocurrency, all of you know that this is nothing but connected with certain kinds of virtual currency, not virtual currency, it will be wrong to actually use this term, but certain kinds of currencies which are basically, what should I say, if I say virtual currency, probably factually it may be right, but this is also connected with privacy law, this is also connected with e-commerce, etc., and also strategies for developing our business laws, especially from the government. Let's talk about criminal law. If you see from the perspective of criminal law cases, criminal law judgments, etc., almost everywhere you'll be getting to see any sort of criminal cases now connected with any sort of cyber crimes, especially for example capturing of the rape scenes, or for example any kind of CCTV camera footage which is capturing any murder scene, any sort of traffic violation, etc. So we need to understand about what is happening on the cyberspace, how the data is being processed, how the data is being accessed, etc., etc. Civil law. When I talk about civil law and contract law are distant relatives, I would rather say. Obviously, there are teachers who can correct me, but still, then I would rather suggest you that look from the perspective of different understanding. If you are looking into civil law, you will also understand about the court management. If you look into the civil law, you'll also know about the uploading of certain kinds of contracts, uploading of certain kinds of legal policies, etc., on the web pages, websites, etc., looking into these laws, and also defacing of certain laws where criminal law comes in, then putting wrong informations in that. Not only that, processing of certain data in the registry office, etc., many things are there. Then obviously coming to the question of contract. Nowadays, even if you go to buy a simple SIM card also, none of us know how the contract is being made. Obviously, we law teachers know, but if you do get to see that any person who is half literate or illiterate also, they're going to the shops to buy the SIM card, and you do not know that how their data is now being processed, how their data is now traveling from country to country, and even not only from country to country, but from surface web to deep dark web, whatever it is. So for all these things, we are getting to see cyber law has got, great significance in contemporary legal practice. Those of us who are basically encouraging our students to go ahead for public interest litigation, we can definitely, when the student reaches fourth year or fifth year or even third year also, we can make them understand that, what is the significance of, filing a public interest litigation basing on certain, like, legal, what should I say, arena, which are touching upon cyber law. Next, let me discuss about history and development of cyber law in India. I know so many of us are actually teaching cyber law. I do get to see that there are several persons whom I personally know who are teaching cyber law in your respective, colleges, and probably all of you would be following this particular, like, instruction or this particular method of teaching about history and development of cyber law. I will also teach I will also follow the same mechanism, but with a twist. When you are teaching about history and development of cyber law, or when you're teaching about cyber law, the first thing comes in our mind is that what is the meaning of cyberspace? Who created cyberspace? Whether there is really any existence of cyberspace, and who is controlling cyberspace, so that we would be able to understand what exactly cyber law stands for. As you can get to see here, if I'm talking from the Indian perspective, we need to start with the understanding of Indian Telegraph Act 1885. First, let me tell you that obviously you're getting to see I have included Indian Penal Code 1860 also is there. You might be asking me the question that why not Indian Penal Code first, and why Indian Telegraph Act 1885? If you remember about Section 5, especially Section 5B of the Indian Telegraph Act, you would be able to understand anything related to surveillance basically started from 1885. And I'm talking about not the, like, private company surveillance, but from the government, basically, like, government related surveillances, etc., government, by the government surveillances, etc. And this is not Pegasus I'm talking about, but this is something which came through the Telegraph Act. What is this? What is the significance of this? Basically, Telegraph Act or the telegraph system started this kind of, like, wired communication system, or transferring of the communication system. The same mechanism has been followed by many other stakeholders who developed the communication systems through the cyberspace, or who developed the concept of cyberspace. In India, basically, for many years, this Indian Telegraph Act 1885 had been in use, especially to regulate, to control cyberspace, specifically to understand that, where the government's rights begin, where the individual's rights end. Not only that, we also do get to see that when the government is basically going for surveillance, okay, when the government is basically intruding into the privacy of individuals, what are the grounds where the government can come up for privacy violation? Rather, I would say, what are the grounds where the government can ask for or can claim that I'm not violating the privacy, but in the name of the security of the country, etc., whatever we do get to see, peacekeeping, etc., etc., we can go ahead for surveillance. After that, we also do get to see Indian Penal Code 1860. Obviously, when 1860 code was created, there was nothing like, communication devices, etc. But slowly we did get to see about the telephone, telegraphic system, which were basically within the, like, power, authority, etc. of the government. Now, if you consider certain small points, it will be easier for you to understand. When the government is using something like, related to telegraph, telephone, etc., if you remember that, what you call riot against the state, sedition, etc., these are all connected with whatever communications are coming, whatever communications can be accessed by the government, and not to forget about the language that is being used for communicating. When I'm talking about the language, then comes the question of Information Technology Act 2000. And do not think that, I'm talking about some code language that the computer uses. This is obviously there, but also the simple communicative language. This is something which is very, very important, very, very significant, because when we are teaching cyber law very recently, basically, we did understand, or we did get to see that, US or many other companies, basically, they are what you call expressing their understanding, they're expressing their wish to use Sanskrit as the code language for computer. Well enough, good enough. But I'm not talking about that also. If you consider certain cases like Shreya Shingal's case, or if you consider any other cases where abusive languages are being used, you would be able to understand where Article 19(1)(a) is mixing with so-called cyber law, is mixing with Information Technology Act 2000. Why the court considered 66A not fit for, existence, whereas, I'm very much dead against complete removal of section 66A. I am for amendment of 66A. However, that's a different issue. But you should also consider this thing that, when the cyberspace law related to cyberspace was developing in India, it is still developing basically. When this was developing, this was being developed, and information technology bill came up in 1999. We are one of the very first countries who basically introduced this bill. This kind of communication related things were not there, except the age old understanding about sexually explicit content or obscene content, etc. Also, do remember, we don't have anything related to pornography. Those of you who are thinking that, pornography is there, definitely it is there, but it is child pornography. When it comes to adult pornography, we have to understand this from the concept of sexually explicit content, like obscene materials, etc. Pornography, I have discussed with many individuals, I have discussed with lawmakers, I have discussed with judges. They refuse to understand pornography can also be legal. Almost everybody stated pornography is illegal. Unfortunately, they are not able to understand sexually explicit content can also be legal, may be illegal also. However, child pornography is always illegal. Given this understanding, we did get to see that Information Technology Act 2000 amended in 2008 came up, and when 2008 amended act came up, it also pulled in certain other sorts of laws which started getting some kind of what should I say development along with the cyber Information Technology Act. What are these laws? Slowly, I will be discussing. Say, for example, child related laws, juvenile justice care and protection related laws, and thereafter women related laws, indecent representation of women, prevention laws. Thereafter, we did get to see that these Indian Penal Code, as I just mentioned, the amendments came up. After that, we also did get to see the POSH Act, that is the prevention of sexual harassment at workplace related acts, etc. Thereafter, we also did get to see that is actually starting from 2010 onwards. Okay. So 2010 onwards, we also did get to see several other acts and several, statutes and several other bills were also coming up. One of these, statutes, I would be definitely, I would like to, what do you call, talk about this. This is related to what is popularly known as SC/ST prevention, related SC/ST abuse prevention, related statute also. There also you would be getting to see that everywhere this concept of using cyberspace for communication, etc., has been given some kind of importance. This definitely adds to the understanding of the cyberspace and laws related to cyberspace, or laws governing the cyberspace. After that, definitely we did get to see about IT Act rules. There are so many rules. These rules also individually must be studied, because if you do not study these rules, especially for the teachers, it will not be possible for you to explain how this particular statute or provision is going to be implemented, is working. After that, definitely, when we are talking about the strategies of cyber, law, teaching cyber law, you would be getting to see cyber law is spreading wing. So actually, cyber law or information technology law or digital communication technology law, etc., they are touching upon everything that every student needs to know. Say, for example, e-commerce, thanks to our unilateral model law, from which basically our IT Act law came. Public transport, access to justice, criminal law, civil law, everywhere we are getting to see that the concept of cyber law is spreading wing. There is a difference between the earlier slide and this slide, that is the scope and application of cyber law. Because everywhere, especially if you see from the criminal law perspective, we are getting to see that evidence law especially, it is demanding, I'm not saying that it is actually asking, it is demanding that every student, every teacher must be knowing about the implication and also the applications of the Information Technology Act. Therefore, you have to understand when you are teaching the students, when you are taking up the subjects, or when you are creating the units, or when you are making your contents for class delivery, you have to remember this in your mind, that how this particular what you call statute, or how this particular legal understanding is touching upon all these aspects of legal education, justice delivery mechanism, or the statutes. Now comes the very important aspect, different divisions of cyber law. Sometimes I have seen that the teachers, especially the teachers who are taking up cyber law as teaching mechanism, they feel that there is only one division for cyber law, that is cyber crimes, and there is another division, that is cyber tort. No, you are completely wrong. Because you have to understand that the students are actually coming, it is kind of like they are coming with a customized knowledge. Some students will be coming with a preloaded information. Some students will be coming with a completely blank mind, that they would like to learn from you. Some students, including some senior or advanced students, especially for LLM, etc., they will be coming with a challenging attitude. So say for example, these are the divisions that I have made, and here also you would be able to understand that why I'm making these divisions. This will be extremely helpful if you are keeping this in your mind to basically teach about certain chapters that are there in the Information Technology law. First division obviously is coming for criminal laws, because cyber criminal laws that we know, especially from chapter 9 and chapter 11, this thing perspective of the Information Technology Act. As you can get to see, consumer law, I know that it is basically showing Kalpesh sir, I am getting to see one notice. So should I approve?
No, madam. I
Okay.
think in annotation maybe they don't approve, because
Oh,
some participants they are creating
yes,
disturbance.
yes. Okay, fine. Fine. Okay, just a second. Okay. Now comes the question of consumer law and division of cyber law. When you are actually seeing the stakeholders liability, because here later onwards also we will be discussing about the liabilities of the stakeholders, we must understand that there is consumer division of the cyber law also. What is this consumer division? Recently we did get to see that there are different codes which are coming up about the responsibility of the service providers for data what should I say, buying of the data packets, buying of the talk time packets, if I use the very common language, etc. Not only that, we are also getting to see about the rights of the subscribers, consumers, etc. There are different rights: right to recognize, right to forget, right to be forgotten, right not to forget. So many things are coming. So in this, and also obviously compensation, damages, etc., that we basically know as a division called cyber tort. But please do understand, before understanding cyber tort, please also remember there's this division of cyber law, that is the consumer division. Next obviously comes the question of international law, because if you do not understand this division of cyber law, it will be very difficult for you to explain what is the meaning of jurisdiction. It will also be very difficult for all of you to understand what are the international instruments, what are the new laws, what are the new instruments that are being made by the international stakeholders to regulate or to suggest certain kinds of cyber security measures. Privacy laws, obviously it is a branch of cyber law now, or rather I would say it is considered as a heart of cyber law now. Then comes the IPR. This is again another division of cyber law. Competition law. Why I'm suggesting that this can be considered as a division of cyber law, because often you get to see that there are judicial understanding not only from our country but from different countries, including from the EU, what you call legal arena, where Google is being fined, for what you call violating the competition laws. Or for example, Facebook is being fined. Facebook or Meta company is being fined. So if you do not understand about competition law and the connection with it or with cyber law, you will not be able to understand, or you will not be able to teach what is the responsibility of Google, what is the responsibility of Meta company, etc. When it is coming to competition law. This is especially related to the bots, related to the advertisements, etc. Next comes the question of evidence law. This is again another division or branch of cyber law, whereby you will be getting to see that evidence law, one, it is actually being taught as a indigenous subject, but now evidence law is also being connected with cyber law, which is being slightly different from what exactly we know as the contemporary or traditional evidence law. Why I'm suggesting this is that in Indian courts we are getting to see that evidence law jurisprudence is basically including, developing, especially from the perspective of cyber law. But if you consider this as a division of cyber law, especially from the cyber forensic division, it will be greatly beneficial for you to basically understand that why evidence law may be considered as a division, especially connected with the cyber forensics. Next comes the question of law of war. Obviously this is coming under the four squares of this laws, so international laws. But law of war presently is very important division of cyber law, especially when you are teaching from the perspective of state sponsored cyber warfare, and also cyber terrorism that is not state sponsored, or rather I would say state sponsored cyber warfare and non-state actors, what should I say, involvement, or non-state actors activities, etc., related to cyber terrorism. So this is also another division of cyber law that you have to keep in your mind. Let me now explain something about administrative cyber law. Now, do not get confused about the actual administrative law and this administrative cyber law. I'm basically putting this thing in front of you, because if you open Information Technology Act, and if you just go through, say for example, chapters, say for example 2, 3, 4, etc., including 5 also, you would be getting to see this is basically touching upon the administrative division of cyber law. What are the things that are included here? Obviously e-governance. Thereafter you'll be getting to see usage of the computer network for the administration of justice. And here obviously this is connected with the e-governance, but what we generally fail, or what we do not include in our actual teaching method or teaching pedagogy, is that who actually controls the computer network system, etc., when it is outsourced, especially for e-governance perspective. This particular chapter and the sections, basically I have seen that most of the teachers either ignore, or they teach in such a manner that the students may not be able to understand. So please do understand that this is the administrative cyber law division, whereby you have to look into these kinds of sections, especially starting from sections, chapter 4, chapter 3, etc., which will be going up to section 11, 10, 10 or 11, whereby you'll also get to see that the connection between e-contract, e-governance, etc., are starting. That's the reason that I'm mentioning here government contracts, outsourcing for managing administrative works, etc. These are all there in the Information Technology Act. Even though we have got lot of scope to do research on this, we have got a lot of scope basically to suggest some kinds of improvements, etc. That's a researcher part. But please look into this particular chapters or sections, whereby we do understand about e-governance and also administrative part of cyber law. Then comes auditing. What is the meaning of auditing? Most of the time I do see that there are teachers who actually neglect this part. Auditing basically is connected with cyber security, and most of the time I have seen that cyber law teachers or the cyber law syllabus creators, they do not concentrate on this, because this is connected with cyber security. Most of the time I have seen that this has been neglected, or this has been left, because it has been understood that this is a part of computer forensic science, or this is a part of computer science, etc. But we are doing injustice by not teaching the students about the auditing. This is basically from, again, you will be getting to see from section 5 to section 10, especially section 7, 6, 6a, etc., whereby you will be getting to see that how the auditing should be done. There are rules are also there. This also you need to actually concentrate. Policy making and cyber law. even though there are no chapters, no sections in the Information Technology Act which basically discusses about policy making and cyber law. But I guess that this, or I think that this should be brought in within the pedagogy, whereby you can discuss about the positive aspect and the negative aspect of any statute that is affecting the actual cyber law. That means the Information Technology Act rules, etc. And obviously surveillance. See, when you go for sections beyond section 75, etc., you will be getting to see the provisions relating to surveillance. If you see even section 354 part, and also if you see IPC also, section 354 series of Indian Penal Code I'm talking about. So this also basically comes within the purview of administrative cyber law, because here you have to teach the students about what is the legal surveillance, what is illegal surveillance. In this regard, I would also like to mention one thing. Many of you may not agree with me, but it is from my own research understanding that I have come to understand. Still now, there is no solid understanding about the responsibility of the admins of WhatsApp groups. And also, there are no solid understanding about the WhatsApp contents, or rather, I would say that what is the admissibility of the contents that are being generated, that are being circulated by the WhatsApp members. So in this regard, you can also think that why shouldn't we consider about the surveillance, about this administrative portions of cyber law, etc., so that you will be giving a very clear picture to your students. Obviously, when we are talking about strategies to teach cyber law, this one basically I have seen almost all the teachers basically they have understood it very well, and they're also teaching in an excellent manner. That is the traditional contract versus e-contract, contract nuances of e-contract, then timestamp, date stamp, managing the data capacity of the contractors, etc. These are very well understood by the teachers, and they're also imparting the education. But please do understand, if you are making certain kinds of questions, that is actually practical questions, do not neglect this particular portion. Why? Because I have seen that there are several questions coming up in the courts of law, whereby this particular question is coming up, that what is the meaning of e-contract, whether a particular behavior between the consumer and the seller or between different stakeholders can be considered as a contract at all. And also, what is meant by implied contract, what is meant by tier wrapping contract, sorry, yes, so what is meant by click wrap contract, etc. These are all there in the law books, these are all there in the if you see certain rules, etc., but we are not teaching the students, maybe because there is a time constraints are there. But we can definitely include these things in the contents, that is study contents, e-contents, etc., whereby the students can understand about different types of contract. Because please do remember, the entire understanding about cyber law, that is information communication technology related law, basically stands on this particular understanding of contract, who is making what kind of agreement contract with which stakeholder, and what does this particular contract say about their mutual understanding behavior on the physical space as well as on cyberspace. As I mentioned about the international law, conflict of laws, this understanding is also very necessary for every teacher to understand. Domestic law versus international law. We all know that there are conflict of laws, there are different principles, there are different theories, rules, etc., to understand which law will be dominating which law, especially when it is being applied in a government or in a country, which law will be applicable when the person is going abroad or when the person is traveling, etc. What is the significance of international law, etc.? We all know. But then try to understand it or try to apply it from the perspective of cyberspace governance related understanding or cyber law related understanding. International human rights versus consumer rights. I know that there are yes, I am getting to see several understandings or several comments. I will be taking up these questions later, but let me finish. Maybe you will be getting your answers also. When we talk about domestic law versus international law, I'm actually meaning not only international law or international instruments, etc., but also domestic laws of different countries, including the policies that are being created or that are being used by different companies. because sometimes we are getting to see that some companies basically are acting as if they are parallel states. That means they have got their own punishment mechanism, they have got their own rehabilitation mechanism, etc., and that is not matching with the government, state, or rather I would say national or domestic laws, etc. If you understand this, it will be excellent for any teacher to explain these nuances to your LLM students, to your PhD, scholars, as well as to your UG students also. And international human rights versus consumer rights. This is something which nobody or none of us basically look into it, because this may not have been discussed such for like what you call explicitly. What is the reason behind this? Because we are very limitedly actually looking into the consumer rights of people, especially on the cyberspace. I would rather suggest that you expand your own research understanding, do a little bit of research about the consumer rights and international human rights. Why? Because if you talk about e-access to justice, if you talk about e-access to certain kinds of what should I say, consumers' rights, etc., you will be getting to see there are a lot of things that we can give to our students, and this will be falling within the syllabus, general structure of the syllabus that we are basically following. Why I'm suggesting this is that there are certain laws, there are certain legal subjects are there whereby as a student even I also used to sleep, and cyber law is no exception for this, especially for those who do not want to understand any new understanding. If you compare this from their own viewpoint, say for example, when I was taking my class on cyber law yesterday, some students came up with a unique understanding about why we should not what should I say, discuss about Snapchat's policies, why we should not discuss about Chat GPT's policies, etc. They are not the teachers, we are the teachers. So I told them that first you have to learn what we are giving you, what we are explaining to you, then you come up with your own understanding. If you actually go according to their demands or according to their wishes, I know that in several universities, government or private universities, basically management will be telling, or the the higher authorities will be telling that give the students their space. Yes, we are giving, but do not think that they know better than us, because most of the time their knowledge is based on Wikipedia, again that may not have any sort of what you call proper legal educational understanding. Their knowledge may be coming up, or their knowledge may be going to the Quora digest, which may not have any authority when we are talking about legal education, especially higher education. Jurisdiction is something which every one of us must be understanding. And if you are talking about jurisdiction, you have to remember about the physical space jurisdiction related what you call theories, principles, etc., and how it is being merged with the cyber law related jurisdiction understanding, etc. Thereafter comes the question of the understanding about intermediary contract, or sorry, I'm sorry, conflict of laws between the intermediaries laws, the users laws, the licensors laws, and the bystanders laws. Why I'm suggesting this thing is that nowadays we are all consumers of information, we are all consumers of data, we are all sellers of data, we are all providers of data. So if the students are not able to understand, or if the students are not able to follow that what is the meaning of intermediary, where the conflict of law is coming between the intermediary and the user, and between intermediary user and the licensor, or what is the rights responsibilities of the bystander, your ultimate goal, or rather what we say as objectives or achievements, etc., that will be completely coming to ground zero. So it is better that we understand about this aspect also. Now comes the question of liabilities again. About this, this actually centers around Section 79 of the Information Technology Act. After that, there are several rules are there which also speak about the liabilities. But again, you have to expand your horizon to make the students understand, and above that, to make yourself understand and also know what is the liability, whose liability, what is the difference between liability and responsibility. Now, let me tell you, this is something which is this information basically I give to almost all the sessions. When I go for any meetings, when I go for any discussions with tech companies, whether it is Google or whether it is Facebook, whatever it is, they always tell me that we do not have 100 eyes, or we do not have 1,000 eyes. So it is the responsibility of the the victim, or the subscriber, etc., to note something and then to make us alert. And thereafter, we will be acting as with due diligence. We will be taking care of that particular issue, and we will be pursuing, or we will be executing our responsibilities. But then, don't you think, especially those who are attending this session, don't you think that all these tech companies and all other stakeholders, they have got their own indigenous liabilities? Responsibility comes when the liabilities are understood. So that also you have to understand. And when you are delivering the lecture, you can just simply add these points so that your lecture becomes more interesting. Thereafter, obviously, comes the question of interpersonal liability. And do not think that I'm telling about interpersonal liability means individual to individual. But I'm talking about individual versus the company, that is the digital tech companies, individual versus the government stakeholders, their liabilities. There are other sorts of interpersonal liabilities are also there. Say, for example, if you are buying simply, or if you are getting, say for example, some kind of net connection from any stakeholders, what is the responsibility, what is the liability? I'll give you one very simple example here. I was basically planning to get another connection, net connection, for my home, and I contacted one of the service providers who provide internet connections for home. And when I got this connection, after 2 days of using that, probably by now most of you would be getting to understand that who is that particular company. They started giving me bill, even though I was told that it is a prepaid bill. So they started giving me postpaid bill. Now this is something whereby immediately I reverted back and I said that I am immediately terminating this understanding, contract, or mutual understanding, whatever it is. The company contacted me, they said that we are giving you 1 month extra, etc. So I told them that you cannot make me a fool, because I am dealing with such kinds of cases, I am dealing with this subject, so therefore you cannot make me fool. Now this understanding comes only when you know that what are the interpersonal liabilities, counting of the stakeholder, and the twisting frames of the liabilities. This also you must be understanding. Intelligence also, we are getting to see there are different kinds of intelligence. This may be broadened understanding of your you can use it as a broadened understanding. Human intelligence, market intelligence, machine intelligence. Why? Because we all know there are 4 pillars of cyber law. If you have studied Lawrence Lessig well enough, if you have not studied Lawrence Lessig, there are materials available on the internet. Please go through them so that you'll be able to understand how the entire concept of intelligence is being formed, framed, and applied. Next comes the question of theoretical understanding of different stakeholders, as I just mentioned. So the government is there, tech companies are there, courts are there, end users are there. All these responsibilities, liabilities, you please go through so that it will be easier for you to understand that, from which perspective you are basically delivering the understanding. Crimes and criminals, now again coming the division of cyberspace, evolving nature of the crimes, that you have to be open minded researcher. Otherwise your students will be learning only certain types of criminal activities. You will not be able to deliver them what are the happening types of criminal activities. Again, here comes the question of which are recognized criminal activities, which are unrecognized criminal activities, which actually needs our research. Different categories of criminals, and how the punishment or how they are dealt by the courts, especially on the basis of their maturity level. These are also found in the what should I say, interconnected laws. Victims and witnesses, this is something which is very very important, especially if you're teaching cyber taught, etc. You have to understand this. I have provided detailed understanding of this in my researches, and including my book also. So again, if you apply victimology, that's the reason that I call it a cyber victimology. There are different kinds of victims. You have to figure out that how the victim can demand or can command the compensation, damages, rehabilitation, etc. And what is the role of the witnesses in this, especially for accessing or providing restorative justice. Cyber criminology definitely is a part of the entire legal education system for cyber law, especially why cyberspace is vulnerable, what makes cyberspace is vulnerable, because this is connected with cyber security understanding. Motives behind cyber crimes, do not think that I'm talking something far beyond, but it is coming because criminology is supported by law. If, like it is my understanding, if there is no law, criminology may not be able to survive alone. Same goes for cyber criminology. Patterns of cyber crimes, because again, it goes back to what is recognized, what is unrecognized, who may commit crimes on cyberspace, tools for committing cyber crimes. These are all again coming within the meaning of cyber security aspects. If you see from the perspective of IT Act, please go through chapter 11, 12, 13, etc. And also certain rules are there that will be beneficial for all of you. Cyber victimology, again coming back, why victimization happens on cyberspace, patterns of victimization, especially who are the vulnerable victims, rights of the victims, and rehabilitation of the victims. We generally do not look into what is the meaning of rehabilitation of the victims. If you are teaching in LLM, then definitely look into all these things so that you will be able to understand that how the rehabilitation of the victims, especially from the cyberspace, can be considered, especially for those who are guiding the PhD scholars also. Penology, this is something which we should take up, because we have to understand what is the punishment for tort, cyber tort, what is the punishment for cyber crimes, what are the divisions of cyber crimes, that means serious crimes, petty offenses, etc. Critical analysis of bail and jail, policies, especially for cyber crimes, there also you should be putting your focus. What happens to the repeat offenders, and what is the methodology for punishment for these repeat offenders. Obviously, as I mentioned about jurisdiction, you would be getting to see there are different aspects of jurisdiction, especially related to cyber jurisdiction. Earlier, there was an understanding that cyberspace is without jurisdiction, but now the understanding has come that yes, there is jurisdiction aspect, especially when we are discussing about Information Technology Act related issues, or for example, digital communication technology law, or for example, privacy, data processing law, etc. So there, these questions keep in mind while you are actually preparing yourself for cyber law classes. Different kinds of jurisdiction, different beneficiaries of jurisdiction. This is something which is a very twisting question. Who are the beneficiaries of jurisdictions? What are the benefits of jurisdiction, etc. Treaties, international instruments, and jurisdiction, how they're helping each other, how they're supporting each other for developing cyberspace, for developing the understanding of cyber jurisdiction, that also you can basically consider. Uh, Now comes the question. Uh, Most of the time, I have seen that the syllabus makers, like half, no, I will not say half, like, 50%, or rather, I would say 60% of the syllabus is connected with intellectual property, 40% is connected with cyber law, and they say that this is the syllabus of cyber law. Then tell me one thing, why do we have another subject called intellectual property rights? Because intellectual property rights is completely different understanding than cyber law. I know that some of you may not agree with me, because intellectual property rights, some of it are also connected with the cyberspace. Yes, we can teach this as a part of cyber law, but this should not be dominating factor in our understanding of cyber law. This is just a part. Remember this thing. Therefore, you have to ask your syllabus maker, or when you are preparing the syllabus, you have to keep in your mind, is intellectual property rights is a part of cyber law, and how much it actually dominates in the entire concept that we just discussed here of the cyber law, cyberspace, cyber law, or rather I would say law governing cyberspace, etc. And why cyber law should be considered as a different subject. Obviously, I have seen that there are certain aspects whereby you can answer this second question. If you take up copyright violation, if you take up patent violation, if you take up any other aspect of IPR, you can say whenever this violation is coming, it is actually connected with cyber law, because there are certain tools that are being used from the cyberspace, or assisted by computer network system, that actually will be helping us to understand exactly what is the what you call subject matter, what is the issue, etc. But that does not mean that the cyber law, the concept of cyber law and IPR, they're synonymous, they're different. So therefore, it is my earnest request, if you are framing syllabus, don't make 2 units for IPR, 2 units for cyber law. Please make it in this fashion: 3 units for cyber law, 1 unit just for some nuances of IPR, because the students will then not come to your class thinking that this is the repetition of our IPR class. Now comes the question of how to frame syllabus of cyber law. I'm almost ending my presentation. After that, I will be putting the platform for question answer. I will be happy to collaborate, assist also. how to frame this syllabus for cyber law. Let me tell you that I have been framing this syllabus for cyber law not only for one university but for many universities. Some have been generous enough to accept my ideologies, accept my opinion, etc. Some actually did not accept because of the challenges that you did get to see that I discussed. First of all, please do remember what should be the objective of your entire syllabus for cyber law. Is it, again pulling that earlier slide, is it only to make the students aware about certain cyber crimes? No. Is it only to make the students feel bored by bringing the IPR related laws? No. This is something whereby you are giving a holistic understanding about information technology, digital communication technology, privacy related issues, cyber security related laws, etc. Therefore, please frame your objective in this fashion. Learning about the learning outcome. Now, all of you, I know that you are working for NAC, your own IQSA departments are after you for NAC related work, etc. There you'll be getting to see what is the learning outcome. Obviously, we have to see that what is the real outcome after this course is finished. What is the learning outcome? Whatever the NAC people say, whatever IQSC people say, in my own understanding, cyber law learning outcome should be preparing proper, armed lawyers. Armed means not the, weapons, etc. But those lawyers will be able to understand what is cyber law, will be able to defend their clients, will be able to defend the rights of the clients. Maybe it is the company, maybe it is the, individuals, whatever it is, they should be knowing about everything, knowing about the course and program outcome also, because these two also differ. This can also be connected with each other, but you have to remember where you are going to limit your syllabus, where you're going to expand, broaden your syllabus, etc. Designing of the units, this is something which is a very much I call it as arty craft, because I recently designed certain syllabuses for my own course also. And while doing that, I actually could understand first, I was very confused that where to begin, where to end. Those of you who are authors, those of you who are researchers, this is my advice. Please do not consider this as your book chapter or your thesis chapter. This is completely different. And remember one thing, you'll be remembered for designing these units, either as a bad teacher or as a good teacher. So therefore, design these units keeping in mind what you can deliver, what other teachers can deliver. Planning for the topics, again, these topics must be chosen very what should I say, importantly, very interestingly, and also very carefully. Because I have seen some universities and also some institutions, they had included the topic called ethical hacking. Now, all of you who are teaching cyber law, you know that ethical hacking is not ethical because this is not legal at all. So if you're teaching the students ethical hacking, what is ethical hacking, how ethical hacking can be done, and whether it has got any legal understanding or not, because I have asked so many students when I entered the class for the first time in any classroom where I have gone for cyber law teaching, I have asked that tell me whether ethical hacking is legal or not. 100% of the students stated that yes, it is legal, whereas there is nothing called legal hacking until and unless the police is giving you or the government is giving you permission. Do not think that any institute, any organization is giving you a certificate course. That means the student is becoming a certified ethical hacker who can go out for hacking. Trust me, I am a cybercrime victim counselor. I have seen cases taking U-turn for this. Designing of the question paper. Again, this is something which is very interesting because you have to this COPO and question paper should be matching. Many of us are doing this work. So these question papers must be designed in this fashion that your program, your units and your own knowledge must be reflecting, and also the students, whatever they understand, must be reflecting in the question papers. Then comes the question of thought-provoking practical questions. Here I must tell, our courts are basically not having many cases from where you will be getting some kind of practical questions. We do have cases, but it is compared, if you compare it with US, UK, etc., we do not have much cases. So such kinds of practical questions must be very much thought provoking. I would like to mention here one thing that couple of days before, I was basically interacting with some government what do you call officials, especially related to the live streaming. And to my dismay, to my shock, none of them could answer anything that could satisfy researchers like us. So therefore, please prepare these practical questions in a very what should I say, uh, very careful manner. teaching tools for cyber law. Obviously, here you would be getting to see that there are different tools are there. Bare acts are there, international instruments are there, then case judgments, observation, precedents are there, not only for cyber law, but also for speech related laws, like, physical offense related laws, you can definitely consider. Case studies, especially this will be very valuable for you if you are, developing something, or if you are trying to tell something specifically related to fake news, or for example, information related news, data related news, etc. Smart applications and devices. The next slide, I'll be explaining this, but please do remember these two, the last one, are dangerous weapons or dangerous tools for teaching cyber law. Therefore, use them judiciously. Challenges. There were, I would like to, explain this: smart teachers versus over smart students. Now, as I mentioned about the tools for cyber law teaching, if you are using some applications like, say, for example, Chat GPT, etc., probably you are delivering to the student what they have put up in the Chat GPT, or you are delivering to the students what they think is correct. This is not correct. Therefore, it is always better to trust in the, trusted information that we are getting to see, especially if you read Bare Act, if you read the explanations, interpretation from the courts, etc. Obviously, when we are teaching cyber law, interpretation of the courts are still challengeable, but still then, please use these kinds of informations or the tools judiciously and with your own understanding. Ever evolving privacy laws. So this is a challenge for cyber law, because today I'm going to teach my students that, this data protection law in India is so and so. Tomorrow I'll be getting to see that has been challenged by different stakeholders. Therefore, please understand that this is a challenge. So therefore, if you're teaching this thing, just teach the basic understanding of privacy related to, like, cyber law or any other concept, and therefore make it open for discussion so that you can basically include the students also in policy making, decision making. Thereafter comes the question of challenges from judiciary. As I mentioned, judges themselves are not aware about certain developments of cyber law worldwide. Judges are also not aware about what is the meaning of live streaming, who are able to see them, and, judges misbehaviors, clients misbehaviors, lawyers misbehaviors, how that is also creating some kinds of laws, how that is also creating some kinds of policy guidelines for us, people. So therefore, these are the challenges which you also, from the researcher perspective, study, and thereafter only you can deliver it to the students, again judiciously. And obviously the study materials. Please do not access study materials from the internet, because most of them are written by undergraduate students who probably have copied it from some other sources. Take it from me, trust it from me. One of my students brought one material which is basically written by me, and he tried to put this assignment to me, and he demanded that I should give him full marks because it is written in a very well manner. When I showed him, line by line, that this is my own article you have copied, then only he could understand what mistake he has. And obviously, he will be getting a big, zero. But still, then you have to be very careful about the study materials, from where you are accessing the study materials, and how you are developing the study materials, so that you are not caught in the plagiarism battle. With that, thank you so much for giving me this opportunity. Again, I thank the organizers, including Shanta Kumar sir, and also definitely Kalpesh sir. Thank you so much for giving me this opportunity. I now what do you call make this platform open for any sort of questions, etc.
Thank you very much, ma'am. I can see you can take more 1 hour. You know, speed up the last half an hour, because I can see a lot of things are there. I
Yes,
can see like it's more than like IT Act, I would say.
yes,
Like I would say, while teaching cyber law, we should focus on, I would say, as per your lecture, I can say I'm not a cyber, like law teacher, but I would say we should focus on 30% on IT and then 70% on other connected thing.
yes,
IT law is the IT Act, but we have to connect with IPC, and then you rightly stated, I would say not less than 10 laws that is connected with that.
yes.
So I request participant to raise their hands. I will unmute them, or you can put your question in the chat box. Obviously, many questions were there, and ma'am uh, also have take a yes, please. Any questions? Yeah, I'm unmuting you. Yes, Sailendra, Sailendra sir, over to you. Sanjay sir, over to you.
Okay. Am I audible, Dr. Kalpesh ji?
Yes, sir.
Okay. So very good morning to, sorry, very good evening to Dr. Kalpesh ji and Dr. Halder ma'am. You have given a very inspiring and thought-provoking and insightful lecture. We all participants are very thankful to you. Just I have one small query, and that is, what is the importance of comparative cyber law in our course curriculum? Should we include the cyber law of Great Britain, America, and other developed countries in our course curriculum? Should we?
Yes, sir. Sir, if you take my suggestion, if you include comparative understanding of cyber law, you can include it just as a topic, because if you include in a unit, then you might not be able to deliver entire thing to the students because of time constraints, etc. Since we are following the semester system also, so I think that it is very good idea to include comparative understanding, and again in that you have to, sir, include certain aspects of cyber law, especially the information technology or digital communication technology law, because in India we have got information technology act, and probably, sir, you also know in other countries this cyber law that we call as cyber law, this is actually merged, or this is included in their criminal law or in different laws, especially related to privacy regulation laws also. So I would rather suggest, sir, if you are bringing this comparative understanding, take a topic, and in that you can basically include this comparative understanding also.
My small second supplementary question is,
Yes, sir.
uh, do you think, as an expert of cyber law, that cyber law should also be taught as a separate paper or separate group of papers at the postgraduate level at LLM level?
Of course,
Because
sir.
uh,
Of course.
because
Yes. Yes, of course.
I don't think that there are many universities those who offer the cyber law at the LLM level.
Yes, sir. Yes, sir. And if you need any help, any collaboration from my side, I'm ready to collaborate with you, sir. It is a very much needed understanding, needed issue.
Thank you so much, ma'am,
Thank you.
for educating us and inspiring us and making us aware. Thank you.
Thank you, sir. Thank you.
Thank you, sir. Ma'am, sir is from senior professor from Faculty of Law, Banaras Hindu University. So, sir,
Yes, sir.
sir. Also, let me take up some more question. If you can raise your hand also, I will unmute you. There is another question. Can we have Indian Cyber Penal Code? There is one of the remarks by Dr. Kamasam, professor
Yes.
from KL University.
Yes.
So your input on.
Yes, sir. Sir, see, I would rather suggest that in the question of this, can we have cyber criminal code? Rather, we should concentrate on cyber penology, because, say for example, our criminal procedural law, our criminal code, etc., they need to be developed. Okay, and in my book, that is cyber victimology, I have basically given a guidance as how the penology must be developed. That means the criminal law, punishment related laws are actually can be framed, and this I'm basically sharing not only from the Indian perspective but also from some other jurisdiction perspective also, especially say for example US, UK, etc. If you see their criminal law, especially the punishment related laws, they have got very beautifully carved out what should be the punishment for certain offenses which are happening on the cyberspace, and also which are happening with the assistance of computers, that we cannot say that on the cyberspace, but with the assistance of cyberspace. For example, sir, ransomware attack, or for example, say for example, this terrorism attacks, physical space terrorism attacks, whereby the terrorists basically are extracting the data, or for example, they are going for data mining, etc. In such cases, what should be the punishment? Not only that, sir, that things that we basically know as traditional cybercrime, for example, doxing, or for example data mining, etc., all these things also, they are basically coming within the broader understanding of criminal law, but there is a division whereby they're discussing that if this is happening on the cyberspace, or if this is happening assisted by the criminal computers, what should be the punishment?
Okay. Pragya Patil, over to you. You have raised your hand. Over to you.
Yes. So good evening, ma'am. I'm Dr. Pradnya Patil
Yes,
from
ma'am.
Oxford College of Law, Bangalore. And basically, my PhD topic was laws relating to e-commerce in India.
Yes.
And actually, I've also done some research on cyber crimes and all that. And it is my strong opinion that cyber crimes and awareness about how to overcome the challenges on cyberspace and related aspects should be part of the curriculum right from the high school.
Completely
This is
agree,
what I
madam.
strongly.
Completely agree.
And
Totally agree.
major problem here lies also with the fact that the enforcement mechanism is very weak.
Yes.
Those people who are supposed to enforce the law are not well trained. They are not aware of how to deal with these kind of issues. While on one hand, the government is trying to say that digitalization is a necessary need of the hour, the government should also try to invest on research and development so that we can have a separate wing, a parallel wing, which can deal with enforcement of these kind of issues. So
Absolutely.
this is my
Absolutely.
opinion. I'd like to know about your opinion also on this.
Yes, madam, in that case, I would suggest that, we can have some kind of, what should I say, session, especially inviting the government, people, say, for example, the police officers, etc., and training them in our institute. That means respective institutes. Why I'm saying is that, say, for example, many of us basically are invited, called for special lectures, etc., in different government training centers, say for example the police training schools or the police training colleges, etc., or even for example for the IRS, like Indian Revenue Service people, etc., or nowadays so we are also getting to see that they say for example bank officers, they're also coming for training, etc. You have to know, sir, know ma'am, that exactly what are the challenges, what you have to tell them, and their acceptability and also their maturity level. Most of the times I do get to see that there are the officers who are coming, they are mostly on the verge of retirement. So what would we do if we are giving the training to those people who are going to retire 6 months after? Nothing can be done. So we have to basically catch hold of the government stakeholders. That is the reason I underlined this understanding of know your stakeholders, and you can definitely tell them that we are organizing for such sessions. This is specifically for these people, so please come and join these sessions and make it mandatory. I know that nowadays there are a lot of say for example, development programs or training programs. So you can say that this is in collaboration. Here you can also get an MOU. You can also get a collaboration partnership, etc. You can definitely go ahead for this, madam.
Yeah, thank you so much, ma'am.
Yes, ma'am.
I have, a little bit of training I did do in some advocate bar association previously.
Yes.
But again, challenge, as you have rightly mentioned, the ability of the person who have attended to grasp
Yes.
the seriousness of the issue. That again, we need to address that issue as well. So maybe a elaborate curriculum needs to be developed so that it can be inculcated right from the high school level, so that they get
Yes.
used to these kind of issues. They understand the seriousness and how to deal with these.
Exactly.
Um, also.
Exactly. Kalpesh sir, is there any judicial officer or is there any retired judge here in our session?
I think it seems no, ma'am.
Thank you. Why I'm asking is that there should be a session with the judges. Otherwise, we will not be able to establish our understanding, so that they will be knowing, what is the problem we are facing
Definitely,
and what is
madam.
the problem,
True.
so that we must be considering.
Definitely, madam. Like, you keep going all over the India, and then, our friend Dr. Chintan Pathak,
Yes,
whenever he keeps sharing this experience, like,
yes,
while training public prosecutor, judicial officer,
yes,
and then
absolutely.
they don't, I would say, they're not having the enough idea, the
Yes,
imagine the how they're handling the cases.
yes,
So
yes,
that is a really, the real reality on the ground.
yes,
We'll be taking this is the last question
yes,
from Siddharth. Ma'am, how can we link forensic research identification method with cyber law, and especially in identifying theft that is emerging a lot? So
yes.
cyber and forensic, that is a question.
Yes, yes. So, sir, I would rather suggest, I mean, if you're asking me about syllabus drafting, in the units, generally we follow 4 units pattern. So in the units, you can also include one unit related to cyber forensics. This can be in the unit specifically designed for cyber crime, cyber criminal laws, etc. So there, or even say for example evidences, etc. There you can include this topic of cyber forensics. Definitely, it is a very much related subject and wanted topic. So I think that you can go ahead for having a topic or chapter on this. Plus, if you are planning for any value added course, there also you can include, so that if you are planning for a 30-hour value added course, you can actually expand your entire unit, and you can give the entire study material or the courses, etc., for the students.
Let me take up one more if you want to take, ma'am, then we will wind up.
Sure.
Could you explain the jurisdiction part where you said there is no jurisdiction in cyber offenses? Over to you, ma'am.
Yes. See, this was the earlier understanding. I told this was the earlier understanding, where it was the understanding that there is no jurisdiction. Basically, cyberspace is without any jurisdiction. But here now presently what we are getting to understand, yes, there is jurisdiction issue. And where you are getting to see this jurisdiction issue, especially there are many principles, theories, etc. There, say for example, long arm statute principle, effect test, etc. All these things are there. So that you have to study that while you are discussing about jurisdiction, that you have to discuss. And only then you can basically make the students aware that, this is not something that the cyberspace is jurisdictionless. This is also connected with jurisdiction, and jurisdiction plays a very significant role in the entire management of cybercrime cases, or even cyber related cases, e-contract cases, many things.
Thank you very much. Again, questions are there. Sorry, we won't be able to take up. It will go for, it will cross 9 p.m. also. So
Yes.
thank you very much, ma'am. If I'm not wrong, maybe, 5% of the faculty may be teaching cyber law. But again, the understanding, like teaching IPC or any,
Yes.
contract law, international law. So that will be in their mind. Obviously, in my mind also, I can discuss those things. Okay, I can take up, okay, this is cyber element is there while teaching contract, or, whichever I would say, many subjects we can connect nowadays, a lot of things in that case. So thank you very much, ma'am. I can see a lot of messages I have received asking your detail and contact details and email ID. So already I'll be sharing in that group.
Yes, please. Yes,
And
please.
sure, ma'am.
You
Thank you
can,
very
sir,
much.
even share my WhatsApp number also. I'm there on WhatsApp also, LinkedIn also. I'm there, especially WhatsApp, because I know that will be quick communication. So please share my WhatsApp number also, so that I can get connected with all of you, sirs and madams.
Okay, sure, definitely, ma'am. So, madam, thank you very much on behalf of the organizing committee, and look forward to see you in future event also. Thank you very much.
Sure. Thank you so
Thank you.
much, sir. Thank you all. Thank you.
Thank you.